I think we got a quorum. We've got a lot of people.
We do. Hi, Leslie from Dothan, Alabama. That's fine.
So, hey, Lake Stevens, Pittsburgh, all around the way. So Joyce and I have this weekly podcast on Tuesday mornings, which we were taking off tomorrow because it's Thanksgiving week. Some people got to cook. Some people got to eat. Some people got to prepare to eat. I'm in that category. But we did say that if there was a ruling or more than one ruling in United States versus James Comey or United States versus Letitia James, that we would try to reach out to everybody and give our quick thoughts. And these are quick thoughts because the opinions just came out. We had a lot of other stuff going on. But the bottom line is, and Joyce, then I'll bring you in. The bottom line is the judge found that the appointment of Lindsey Halligan for purposes of both the Comey case and the James case, that appointment was invalid. But she says that's not the only question. The other questions are, so if the appointment was invalid, what does that mean for the indictment? And what's the remedy? Joyce, do you want to discuss why it was found to be invalid, the appointment?
Yeah, so I mean, for starters, just remember that this is the case that's not being decided by the trial judge. This is the case that, because it involves whether this U.S. attorney is properly the U.S. attorney, the chief judge of the Fourth Circuit assigned it to a judge sitting in South Carolina, which is also in the Fourth Circuit, Judge Cameron Curry. And so she's the one who entered this opinion today. Preet loves to talk about procedure, and this is a purely procedure. You do. I mean, you always emphasize how important procedure is, a view I ascribe to. This is a procedural decision. This has nothing to do with the merits of the case whatsoever. It simply says, and this is the holding, that this U.S. attorney was not properly appointed. She was the only prosecutor in the grand jury, the only prosecutor who signed the indictment. So it's void. She's not the U.S. attorney. She can't indict the case. And after considering arguments that the government makes, Pam Bondi tries to go down fighting with the ship, making the argument that she retroactively adopts everything that Lindsey Halligan did, and the court says, nice try, no cigar. But the reality is that because she was not properly the U.S. attorney, this indictment is void. And the most interesting part of this decision, which I think runs about 24 pages, it's not long if you want to take a stab at reading it, but the judge says that she has considered Jim Comey's argument. And of course, this applies to Letitia James too. But the Comey case is, I think, of the two, the more interesting, because the statute of limitations for charging Comey ran just days after he was indicted. And that would mean that this case could not be re-indicted, potentially. There's a lot of ins and outs here. That might be the case with James too. Her statute of limitations computation is not clear to me. But in any event, the judge says she's not going to dismiss the case with prejudice. She's going to dismiss it without prejudice, which gives the government the opportunity to re-indict if they can. And the reason that she does that, she says that what the law requires her to do is to restore Jim Comey to the position that he was in before the indictment was brought against him. And that would, in essence, mean the position where he still could be indicted. So it makes a certain amount of sense as a logical proposition, and it's a very well-written opinion.
Yeah, we should just remind folks on the appointment issue, without going into the weeds of the statute, amendments to the statute, and everything else. The point is, that I think everyone can understand if you understand anything at all about the separation of powers, is even though this president thinks that the unitary executive theory is one to be espoused and should be entertained by everyone on the Supreme Court and otherwise, and that he has unrestricted and unfettered authority to do all sorts of things relating to the troops, to law enforcement. He claims that he is the chief law enforcement officer of the country. Notwithstanding all of that, there is a role that the first branch of government, the Congress, plays in the appointment of members to the executive branch. So you have an executive branch, yes, but it's populated by a lot of people, including folks who have to be nominated to the Senate, and then with advice and consent of the Senate, confirmed or not confirmed by the Senate. So you have an entire class of people, including cabinet secretaries, United States attorneys, ambassadors, and others who are in the executive branch, yes, but the president can't appoint them without regard to the other branch of government because of the advice and consent clause. And that is true of U.S. attorneys as well as a matter of statute. Without dealing with all the mumbo jumbo and the in the weeds stuff, essentially, if the president's team had its way, they could indefinitely and essentially forever bypass the advise and consent requirement of the Senate by simply putting in people for 120-day periods or having people retroactively appointed as special attorneys. It undoes an important feature of our separation of powers and checks and balances, which is that certain people, certain officers, either by virtue of the Constitution or by congressional statute, you have to have a role for the Senate. And if you don't have a role for the Senate, that is wrong and improper, and that's what happened here. Right, Joyce?
I think that's absolutely right. There's a little bit of a ticking time bomb here for the defendants, though, which is this. The government will inevitably make the argument that having the district court appoint a U.S. attorney, even a temporary one, violates the separation of powers. Because after the 120-day period during which the Justice Department, the president, can appoint an acting U.S. attorney, without benefit of Senate confirmation, after those 120 days expire, you cautioned me against getting down in the weeds of the statute, which is a place I hate to go, but here I am. 120 days. Once that's over, the court gets to appoint the U.S. attorney until the president nominates and the Senate confirms a new appointee. And I had frankly worried about that ticking time bomb of an argument. The government would go in with separation of powers. Maybe the Supreme Court would buy it. But now that I've read Judge Curry's opinion, I'm actually less concerned because the argument that you explain is the argument that she makes. The primary concern here is making sure that the president, the executive branch, doesn't have unchecked power to put in place whoever it wants to put in place. And so whether it's Congress or the courts doing the checking, the legislative history is clear that the president's power shouldn't be unfettered. And in the context of, there's a whole series of U.S. attorney appointees where this has now become a live issue. Highly qualified people like Alina Habba and Lindsey Halligan. I think that the government is not on a good, solid footing here.
Yeah, look, which doesn't mean the president doesn't have all sorts of authority. There are thousands of employees that the president gets to appoint without any interference or intrusion from anyone else. So, for example, Marco Rubio, if he wants to make him national security advisor, which he has done, good for you. He can do it with essentially no restraint at all. If he wants to make him Secretary of State, which he did also, he has to go through the Senate. Joyce, how can it be that a judge, for a layperson, that a judge renders a decision about the invalidity of the appointment of Lindsey Halligan and doesn't make clear in the decision whether or not Comey and James are out of the woods? Doesn't address that issue. And your answer is, I know your answer, and it's what?
Yeah. That issue was not in front of the judge. That's an entirely different question. She was brought in to answer only this one issue. So that sort of is the pregnant hanging pause at the end of her opinion. She does do a little bit, by the way, to address it, at least in one footnote near
Footnote
the end.
21.
She's making an argument. And it really is a good opinion. I would encourage you to read it. But she's making this point after Pam Bondi tries to backbless the indictment by saying that she adopts everything that Lindsey Halligan did, and she would appoint her as a special prosecutor and yada, yada, yada. And the judge isn't buying it. And she drops a footnote simply to note that although indicting a case normally tolls the statute of limitations, a bad indictment doesn't do that, and you might have it in front of you, Preet. We should read the language itself.
Yeah, so generally the return of an indictment tolls means sort of pauses the statute of limitations on the charges contained in the indictment. An invalid indictment, this is quoting other cases, an invalid indictment, however, cannot serve to block the door of limitations as it swings closed. Good metaphor for the door.
It really is nice.
It says, but if the earlier indictment is void, there is no legitimate peg on which to hang such a judicial limitations tolling result. Is that what we lawyers call dicta?
That would be dicta, which
Oh my
means that
gosh, you have
it's
to
not
explain dicta now.
binding. Dicta is a court opining in a non-binding way. And look, she's relying on two district court opinions here. One is from Maryland, one is from Illinois. So they wouldn't necessarily, although Maryland is in the Fourth Circuit, but they wouldn't necessarily be binding. They're district judges' opinions. I think, though, that the entire structure of her argument reaches towards that point and, in essence, says we can't reward the government for acting in bad faith. The government had a deadline. It knew it had a deadline. Instead of putting someone into the grand jury who was competent to indict the case, the government chose to play politics, and the government now should bear the burden for that. But that's a decision for another judge, not for Judge Curry.
People will ask the question, can this be appealed? It can it not?
It can be. I suspect the government is on sort of the horns of a dilemma here because it has other U.S. attorneys in similar situation. It may really want to challenge the substance of this decision, right? It may really want to try and get a judge to say, no, these U.S. attorneys were properly appointed. And so that seems like it might be a driving force here.
Can I ask an odd question? So,
Mhm.
the Comey side won, essentially, but it didn't get that definitive result that it wanted, which was dismissal with prejudice. There would be a circumstance in which, in this scenario, the defense appeals?
Jim Comey is now out from under indictment, and it seems to me like it wouldn't be
A good
a,
place
a
to be.
s- a smart exercise of power to appeal. The weird thing about this, right, is that both he and James have these very powerful motions to dismiss for selective and vindictive prosecution pending,
Right.
and they don't get decisions on them. However, if the government decides to re-indict them, in some ways, those motions would be even stronger following this sort of an interlude.
I think we skipped something.
What did we
Um,
skip?
well, I think you made a point. Well, maybe I missed a step. There are still pending those dispositive by dispositive, case-ending motions
Yeah.
based on vindictive and selective prosecution, which we've talked about a lot, which are in some ways more understandable. Some facts relating to that are in this opinion. The smoking gun message. What about Comey, Adam Shifty Schiff, Letitia, where Trump basically commanded and directed publicly, by accident, it seems, his attorney general to bring these charges. So don't those motions still have to be decided, Joyce?
They can't be decided now. Was that your
Why
Dahlia
not?
just saying that we both look great? I was reading the comments. I think that was your wife saying that we both look good. If so, thank you. But I distract myself now. Look, I think, the issue in this situation is that the motions can't be decided now because this case is over. A judge has dismissed it. Could Judge Nachmanoff sort of cutely sort of side door in and file his, he's clearly working, right? He's taken briefs, he's working on an opinion, not necessarily directly on selective and vindictive prosecution, but on this whole grand jury abuse issue involving whether the indictment was presented to a grand jury, which it doesn't look like happened. So maybe he'll want to say something, but, my read is that the case is dismissed. There's nothing left there for him to rule on.
People will ask the question. I haven't thought about it enough, and I don't have enough intel. Is that a decision that a judge might wish to avoid and say, like, oh, good, great, I don't have to decide that now? Or is that judge at home annoyed because that judge wanted to issue an opinion because it's a great consequence and a great moment, particularly to some other people who are in the dock? Do the judges coordinate and say, we'll simultaneously release our opinion so neither is divested of jurisdiction for the purposes of making an important ruling?
I mean, we don't know
Multiple
for
questions.
sure,
We don't know,
right?
right?
We don't know. I don't think that there would be anything improper about the judges coordinating, but maybe one or both of them did think that they shouldn't talk to each other about the cases and should just go on their own timing. Um, And there's an interesting issue. I mean, I'm assuming for purposes of this argument that Judge Nachmanoff would have granted a dismissal based on selective and vindictive prosecution. And maybe he would not have. And by dismissing on this procedural basis, perhaps that issue is held back for another day and a different judge.
Maybe this is what you
But
said.
I think he would have dismissed.
Well, let's suppose that the other judge planned to dismiss with prejudice, and this judge dismissed without prejudice. A layperson might ask, well, isn't there still a reason to issue the opinion with prejudice because that's a stronger remedy? Does it make sense and for due process and in fairness for that other judge to be precluded from disposing of the case once and for all if that was the right decision to make?
If that's where Judge Nachmanoff is, not that I ever give advice to federal judges, but what I would do if I was him is the case that will be dismissed is his case. So I think in some sense, he would have the ability to enter a final order of dismissal. And he might say, by order of Judge Curry, this case is now dismissed. Had it not been dismissed, I would have ruled against the government on the selective and vindictive prosecution motions, or maybe on the motion about whether the indictment was properly brought. My decision would have been with prejudice. If the government brings its case again, that will be my rule. I mean, I guess you could do that. It feels a little bit too cute by half once you've been divested of jurisdiction. But
I think all the
it's
lawyers
an
are
option.
probably no. So, I have a final question before we go. All the lawyers are going to be working tonight.
Yes.
A, do you think I should only have an A, I don't have a B. Can you have an A if you don't have a B? I think so.
No, you can't.
Jim Comey put out a little video.
He did.
Well-spoken and articulate as always. And he said this is a win for the rule of law. Do you agree?
I do agree. It is a win for the rule of law. A federal judge has called out the Trump administration for playing little monkey games with appointments. And this is long overdue. It's something Trump did during the first administration. I mean, do you remember by the end, he just had actings all over the place in violation of the Vacancy Reform Act. And there was a lot of litigation over the legitimacy of their decisions. This is something that the courts need to put a stop to. They need to tell this administration to put its appointees in place consistent with the Constitution, full stop.
Joyce, it's a delight and a pleasure to be with you. Maybe something else will happen in the next 2 days.
But I hope not. I have turkeys to prepare.
You do.
Pies
I have turkeys to eat. I have turkeys to eat. Folks, happy Thanksgiving. Happy Thanksgiving, everybody. The rule of law still has force and still has favor. I think in this country, that's one of the things that Jim Comey has been saying. I also think it's a victory for the rule of law. We will see what happens.
See y'all after the holiday.
Thanks, everybody. Back to work or whatever you do at 6 p.m. Eastern time. Take care.
Bye, Preet.